I want to thank everybody for attending. I think this is a very important hearing. My father used to always say there were two things you rarely heard in Washington, and that was either a moral argument or a constitutional argument. So today we are going to discuss the Constitution and how we go to war and what is the Constitution's approach to war. For years now, though, critics have complained that the global war on terror has never really been authorized by Congress. After the attacks on 9/11, President Bush did his constitutional duty. He asked Congress to authorize war against the people who attacked us on 9/11 or anyone who harbored them or aided and abetted those who had attacked us. If you read the authorization, it's actually very specific. Bush originally asked for more expansive language, but Congress insisted on narrowing the mandate to use force against only those who either attacked us or planned the attack or harbored the attackers. Force is authorized against unnamed entities, but they are narrowly defined by their relationship to the attacks of 9/11. Authorization was not given for a global war on terror or against radical Islamists or separatists or insurgents in various civil wars. Authorization was not given for associated forces. Authorization was specific and solely to be directed against the people who attacked us on 9/11 and anyone who helped or harbored them, period. It is safe to say that no one in Congress believed that we were voting or that they were voting for a worldwide war on terrorism in 20-some-odd countries that would go on for decades. So intellectually honest observers have for years now complained that the 9/11 authorization of war does not cover the wars being fought throughout dozens of countries in Africa, the Middle East, and the South Pacific. So basically, the expansion of the war on terrorism really has occurred without the required constitutional authorization. Senators Corker and Kaine and others wish to rectify the lapse in constitutional declaration of war by passing a new authorization for force. I don't disparage their effort. Their motives are genuine. But really, there are two big issues here that need to be fully debated. Number one, does it matter who wields the power to initiate war? Our founding fathers believed strongly that it did. They squarely delegated the power to declare war to Congress. Madison put it this way: the executive is the branch most prone to war. Therefore, the Constitution, with studied care, vested that power, the power to declare war, with the legislature. So yes, it is the job of Congress to declare or initiate war, and Congress has been negligent for over a decade now. Congress has not done its job. Congress has let president after president strip the war power from Congress and concentrate that power in the executive. The second and inseparable issue is when and where should we be at war? It is not enough to say Congress should authorize war. The bigger question is where and when should we fight? Our job is not just to put a congressional imprimatur on war. The vast and important job of Congress is to decide when and where we go to war. The debate that should ensue must ask, are we to authorize the status quo? Are we to authorize war in all of the theaters that various presidents have taken us? Or should Congress limit the scope of worldwide wars we find ourselves involved in? Here, the Corker-Kaine authorization fails us. The Corker-Kaine authorization does not limit the scope of war. It merely codifies the status quo. And I would argue actually expands the current theaters of war. Corker-Kaine authorizes war against at least 8 groups that are known to operate altogether in over 20 countries. Hardly sounds like we'll have any less war. Equally concerning is that Corker-Kaine unconstitutionally delegates or transfers an enumerated power from Congress to the President. Article 1, Section 8 gives Congress the sole power to declare war. Corker-Kaine initially authorizes war against 8 groups, but says to the President, hey, you get back to us. Give us an initial list in case we missed anyone we are currently at war with. And by the by, if you want to add any associated forces to the list, please send us a report. So this authorization transfers the power to name the enemy and its location from Congress to the President. Worse yet, this authorization changes the nature of declaring war from a simple majority affirmative vote to require a supermajority veto-proof vote to disapprove of presidential wars. So if the President defines a new associated force that our military will attack, the only way Congress can stop that President is now a 2/3 vote to overcome his veto. The Constitution is flipped on its head. This authorization fundamentally transfers the delegated power of war from Congress to the President. The hearing today is convened to explore precisely that question. Can Congress transfer the power to declare war to the President? In that context, we will discuss the constitutionality of the Corker-Kane authorization for war. I hope we will have a spirited discussion. With this, I'd like to recognize the ranking member, Senator Peters.
Well, thank you, Mr. Chairman, for calling today's hearing. I continue to be impressed with your willingness to have the subcommittee tackle the big issues, and no issue certainly is bigger than war powers. Voting to send our sons and daughters to war is the most important and the heaviest responsibility that a member of Congress bears. We must never forget that while the sacrifice of war is borne by our service members and their families, under Article 1, Section 8 of the Constitution, the responsibility of asking for that sacrifice is ours. And yet today our warfighters are serving in harm's way in places that have never been named in any declaration of war and facing adversaries that cannot be found in any authorization of military force. The framers, in their wisdom, separated the power to declare war from the power to wage it. But, Mr. Chairman, as you've observed, the reality is that we are at war anywhere and any time the President says so. In failing to assert our war powers, we have effectively ceded them to the President. Ceding war powers to the President is a way for us to play it safe. In avoiding a declaration of war and in keeping force authorizations vague and malleable, we can blame the President when things go wrong. But we must not shirk our constitutional responsibility in favor of political expediency. We owe it to our service members and their families to roll up our sleeves and to have this debate. This is not a partisan issue, nor should it be. Congress hasn't declared war since World War II. President Obama did not seek congressional authorization for the use of military force in Libya, nor did President Trump seek congressional authorization for military action in Syria. The 2001 authorization of use for military force against al-Qaeda has now been used by 3 presidents to support combat in countries with no nexus to 9/11 and against organizations that didn't even exist then. It offends common sense in my mind, and that's why I supported Senator Paul's efforts to repeal the 2001 and 2002 authorizations of use of military force. The world has changed since we last declared war in 1942. Our adversaries often wear no uniform and swear allegiance to no nation. The technology of war has evolved in ways that would be unrecognizable to the framers. Our military can impact world affairs in an instant with a drone strike directed remotely from inside the United States. How we authorize war must adapt to the changing threats and technologies. But the principle of separation of powers and animated the drafters of this Constitution is as sound today as it was in 1789. The power to declare war and to authorize military force is Congress's most sacred responsibility. We must reclaim it. I know that our witnesses have spent a lot of time considering these issues, and I'm eager to hear your views. I want to know more about the cost of congressional inaction and ideas of reasserting our constitutional authorities. And I'm heartened by the bipartisan engagement today and hopeful that we can find solutions together. I yield back.
Thank you, Senator Peters. Let me begin by noting that several senators who are not on the subcommittee have requested to attend due to their interest in the important issue. Therefore, I'd like to ask unanimous consent to allow Senators Sanders, Merkley, and Senators Lee and Udall, should they come, to fully participate in the hearing. Our first witness will be Judge Napolitano, who is currently the senior judicial analyst at Fox News Channel. Judge Napolitano is the youngest life-tenured Superior Court judge in the history of the state of New Jersey. Following his service, he began teaching constitutional law at Delaware Law School for 2 years and at Seton Hall Law School for 11 years, where he was chosen by the student body as their most outstanding professor. Judge Napolitano has authored 7 books on the U.S. Constitution, lectures nationally on civil liberties in wartime and the rule of law, the U.S. Constitution, and human freedom. Judge Napolitano, you are recognized for your opening statement.
When I asked my bosses at Fox if I could participate, There you go. When I asked my bosses at Fox if I could participate in this proceeding, they asked if Senator Sanders was going to be here, and I said, yes, he is. And they said, well, we're dying to see Bernie Sanders cross-examine you. I said, it won't be a cross-examination. We agree on everything. Well, we'll let you go anyway. You know me as a commentator on television. I have also been a professor of law at Delaware Law School, at Seton Hall Law School, and at Brooklyn Law School for a total of 16 years. I have published 9 books on the Constitution, and much of my work has concentrated on the separation of powers. We often begin the first day of constitutional law by asking the students, what's the most distinguishing feature of the American Constitution? It's the first day of law school. Most of them will say freedom of speech, protection of privacy. Some of them may even say due process. But I impose upon them the observation that even the constitutions of totalitarian countries guarantee freedom of speech and privacy and due process, but only ours has the strict separation of powers. The structure of the Constitution, with the primacy of the Congress in Article 1, is a profound demonstration of the commitment of the founders to this sacred ideal. And though Senator Peters has argued eloquently that the separation of powers is the value and the ideal, unfortunately, it is not always the practice, because presidents have assumed that they can utilize military force if they think it is popular, because the Congress will sit back and do nothing. I mean, all that is necessary for the triumph of evil is for good men and women to do nothing. When the Congress looks the other way, as it did when President Obama bombed Libya and when President Trump bombed Syria, this is effectively an amendment of the Constitution by consent. We consent by our silence to the President of the United States usurping the authority that the Constitution gives to us. That authority is unmistakable. If Madison was clear about anything, he was clear that the war power is the most awesome power the government can wage, and it can only be reposed in the legislative branch. The very practical reason for that is war is a failure when it lacks broad public support. And only the Congress has its thumb on the pulse of the people to determine whether war enjoys broad public support. Now, the President and the Senate have entered into treaties, and Congress has enacted statutes which give the President a little bit of leeway. If an attack is imminent, he doesn't have to wait for the first missile to come. And if we've signed a treaty with an ally and the ally needs assistance immediately, he doesn't need Congress's intervention there because the treaty's been ratified, and under the Constitution, a treaty is up there on the hierarchy equivalent to the Constitution itself. But does the President of the United States of America have the power to bomb another country which poses no imminent threat to the United States of America? The answer is very clear, and it is a loud and resounding no. The President does not have that authority. When members of Congress look the other way, it is either because of a belief that what the President is doing is popular, let him take the heat, a belief that what the President is doing is wise. We haven't been asked to get involved. We don't want to get involved. We're running for election soon. War may be popular. War may be unpopular. Whatever is going through the minds of members of Congress, it is not fidelity to the Constitution. It is not fidelity to the separation of powers. I was interviewing a member of Congress whose name I won't mention at the very moment that we broke into broadcasting to announce that the President was bombing Libya. I said, you're of the same party as the President. What do you think about this? Well, the President doesn't have the authority to do this. We all know that. What are you going to do about it? Probably nothing. We're on spring break. He's in Brazil. This is when President Obama made this announcement and when the bombing occurred. And when the congressional break was over and the President returned from his trip to South America, nothing had happened except that the Constitution was weaker and the power of the presidency was stronger. Gaddafi was about to be killed in a horrific way. If Gaddafi was so evil that he ought to have been killed by American forces, only the Congress can unleash those forces. Madison could not have been clearer. What troubles me the most is the precedential value that comes about when Congress looks the other way. I'm not here to criticize President Trump. This is not an argument about politics. This is an argument about principle. But he had reason to believe that Congress would do nothing because Congress did nothing in these other instances in which presidents went to war. Mr. Chairman, I would argue that the AUMFs are unconstitutional because they don't have an end point, because they unleash the president to pursue who he wants for as long as he wishes to do so. And I would encourage you to repeal those AUMFs, but not to replace them with Corker Kane. And Senator Corker's a friend of mine, Senator Kane's a friend of mine. This is hardly personal. But as you yourself, Mr. Chairman, have pointed out, at the present time, the president, goes around the world, and I don't mean President Trump. Presidents go around the world looking for monsters to slay, and when it's popular or when, in their view, it's moral, they slay them, and Congress does nothing about it. But when this behavior becomes a precedent for future presidents to do it, when a president in this era can rely on a document of no moral and legal value, like the two AUMFs, and the Congress does nothing about it, the Constitution is being amended by consent. I only have a few seconds left. Corker Kane. Look, if the Congress decides to withdraw funds for some military excursion, the president will veto the act of withdrawal, and then it will require a two-thirds vote of both houses to overcome that. So a president with 1/3 plus 1 in either house can wage war on any target at any time the president chooses to do so. That is so contrary to what Madison intended, so contrary to the plain meaning of the Constitution, so violative of the separation of powers as to be a rejection of the oath to preserve, protect, and defend the Constitution. And none of you wants to reject that oath. I look forward to your questions after hearing from my learned colleagues.
Thank you, Judge Napolitano. Our next witness is Professor Jonathan Turley. Professor Turley is a nationally recognized legal scholar who has written extensively in the area of constitutional law. Professor Turley has served as a consultant on homeland security and constitutional issues and testified before the House and Senate on constitutional and statutory issues. He has been ranked among the top 10 lawyers handling military cases, top 50 most cited public intellectuals, and the second most cited law professor in the United States. Welcome, Professor Turley.
Thank you, Chairman Paul, Ranking Member Peter, members of the committee. It's a great honor to come into this committee to speak about this weighty issue of the Constitution. Indeed, if there is a sacred article of the Constitution, it is Article 1, Section 8. It's not merely a constitutional, but a moral responsibility. Indeed, the words, Congress shall have no power to declare war, fails to capture the moral imperative. It's not simply a power, but rather an obligation that is meant to adhere to each member when you raise your hand and you take your oath of office. At the earliest stages of our republic, members began to struggle with this responsibility. Regrettably, S.J. Res. 59 is the ultimate and perhaps inevitable end to that process. The new AUMF amounts to a statutory revision of one of the most defining elements of the United States Constitution. We find ourselves at this ignoble moment, not by accident, but by decades of concerted effort by members of this institution to evade the responsibilities given to them by the framers of our Constitution. The result is that our citizens are taught, our children are taught, a false assertion that members of this body will declare war and have the sole responsibility to do that. After all, the provision speaks loudly to that, clearly to that. What this does, and what past AUMFs have done, is to reduce that very loud declaration of your responsibility to what Macbeth referred to voices full of sound and fury and signifying nothing. My written testimony details the express intent of the framers. I just simply note one aspect that I find most telling. We have plenty of quotes from my favorite framer, James Madison, but from virtually every framer. This is one of the few points upon which there was almost unanimity. I say almost because Pierce Butler actually proposed to give this entire power to the President of the United States. He didn't receive a second. He spoke to a room of framers and made that proposal, and not a single one seconded that motion. That was one of the most important moments of our republic. That silence, the absence of a second, shows where we began, of men of conscience and principle who knew that they had to strike this compromise, to restrict the powers of the presidency and to give this sacred duty to this institution. It was a compromise, but of course it's hard to see how that expressed language got us to where we are today. In almost 250 years, we've had 5 declared wars, only 11 declarations in those 5 declared wars. It actually began poorly. We didn't even get out of the 18th century before members of this institution found ways to get around this duty. When John Adams wanted to start the quasi-war, to his credit, they did put forward legislation that referred specifically to the French vessels that could be boarded, but it wasn't a declaration. So we weren't even out of the 18th century before politicians found a way to get around this duty. Now, our last declaration was in 1942, and it has made a mockery out of the statement of George Washington in 1793 when he said, "The Constitution vests the power of declaring war in Congress." And he added this, "Therefore, no offensive expedition of importance, no offensive expedition of importance can be undertaken until they have deliberated upon the subject authorized such a measure." We've made a mockery of that statement. We've made a mockery of Article 1 and Section 8. Now, before I mention some of the flaws I see in this legislation, I want to note one thing, and this sort of reflects my friend in terms of what he had said. There is a path dependence with AUMFs, this assumption that we should only be debating the scope and the standards by which a president has to satisfy. There's still the original question. Many of us do have constitutional reservations about the AUMFs. If anything, the wisdom of the framers has been made evident in our modern history. We're at war everywhere, always. We have forever war. That wasn't the framers' fault. That's in direct violation of what they thought would prevent it. They hated war. Framers despised it. And they believed that presidents and chief executives were naturally inclined towards war. That's why they made this such a clear standard. Now, in my testimony, I talk about the problems that I see in this proposal and why I think it's worse than the current AUMF, which takes quite an effort. I will not go through all the details about how the new nations or countries that are added, the associated forces, the shift from an ex ante to an ex post action. All of those are fundamental flaws that go even further from where we were. The ex ante, ex post problem, I think, is really the signature moment of this law. So this body has failed historically to require a declaration. So they got rid of the declarations. And then they failed and got rid of the need to specify as to nations we're going to go at war against. And now they're about to get rid of even the requirement to get any type of prior authorization. It'll make this body a pedestrian to war, and it will put war making on autopilot. And this law does not even have a sunset provision. It just goes on. And I could see why that's so tempting to have. It certainly relieves members of this body of the rather uncomfortable questions that do come up. But in my remaining few seconds, I will simply note this. Under the past circumvention of Article 1, Section 8, under the former AUMFs, We've gone through 17 years of war. You adopt this proposal, we'll have 170 more, because this has virtually no standards. It will effectively revise the Constitution of the United States without an amendment. I've had the honor of testifying before this body, also your counterparts in the House, many times. But today I took a step that I have not done before, and I've asked 2 of my sons to come with me. I have 4 children. My sons Aiden and Jack are behind me. They are both either at draft age or about to be at that age. I felt that they should be here to watch part of this process, because they may well be asked to pay the ultimate price for the authority that Congress may soon bestow upon the President. If called, I think they will do, and I know they will do, their duty, as did their grandfather and great-grandfather and other people in my family in previous wars. I don't have any question about them doing their duty, but I do have a question whether members of this institution will do their duty and stand with the express language of the Constitution, reject this proposed AUMF, and show the framers that the faith that they put into this body was well placed. Thank you again for the honor of appearing before you today, and I'd be happy to answer any questions you might have.
Thank you, Professor Turley. Our next witness is Christopher Anders. He is the Deputy Director of the Washington Legislative Office of the American Civil Liberties Union. Mr. Anders leads the ACLU's Washington-based advocacy on topics of war authority, detention, torture, and Guantanamo issues. He has also written extensively on the topic of the authorizations for the use of military force, declarations of war, and separation of power. Mr. Anders.
Thank you. Chairman Paul, Ranking Member Peters, and members of the subcommittee, the American Civil Liberties Union would like to express our appreciation for you holding this hearing today. No decision by government is graver or more consequential than the decision to go to war. Over the many years since Congress passed the AUMF in 2001, the ACLU has dedicated ourselves to defending civil liberties and human rights that have been jeopardized by, at best, tenuous claims of the 2001 AUMF as legal authority, or more chillingly, by presidential claims of Article II authority in the complete absence of any advanced congressional authorization. These harms have included the drone killings of even an American citizen, broad surveillance of American citizens, the kidnapping and torture of suspects, and indefinite detention without charge or trial, even of an American citizen apprehended here in the United States. While it would be impossible for one Congress to undo the damage of nearly 17 years of presidential overreach and congressional negligence, we propose in our written statement a 3-step process for Congress to reclaim its exclusive constitutional authority to decide whether the United States should be at war. For now, in my oral testimony, I'll focus on the most pressing first step. Dr. Paul, to apply to Congress a first principle of medical care, first do no harm, the top priority for this Senate must be to ensure that SJ Res 59, the Corker-Kane AUMF, does not become law. It would be hard to overstate the depth and breadth of the dangers to the Constitution, civil liberties, and human rights that would be caused by the Corker-Kane AUMF. The damage would be colossal. Not only would it almost irretrievably cede to the executive branch the most fundamental power that Congress has under Article I of the Constitution, the power to declare war, but it also would give the current president and all future presidents authority from Congress to engage in worldwide war, sending American troops to countries where we are not now at war and against groups that the president alone decides are enemies, against groups that don't even exist today. The Corker-Kane AUMF would authorize force without operational limitations against 8 groups in 6 countries. The president could then add to both lists as long as the president reports the expansion to Congress. To be clear, the president would have unilateral authority to add additional countries, including the United States itself, to the list of countries where Congress is authorizing war. And the president would have unilateral authority to add additional enemies, including groups in the United States itself, and even individual Americans under its new authority for the president to designate, quote, persons as enemies. Although Congress could bar an expansion to additional countries or additional groups, Such action would effectively require a two-thirds majority of both houses, given that the president presumably would veto legislation to curtail an expansion that the president himself has ordered. Every president, excuse me, for the coming decades would effectively be able to claim for the executive branch much of the power that the Constitution gives to Congress and gave to Congress exclusively. Before closing, I wanted to point out a sleeper provision with the innocuous title, Section 10 Conforming Amendment. This provision greatly expands the scope of the infamous 2012 NDAA indefinite detention provision. In its single sentence, Section 10 of the Corker-Kane AUMF would expand the NDAA indefinite detention authority by adding this new AUMF as a basis for the military to capture and imprison individuals in indefinite detention without charge or trial. The Corker-Kane AUMF, like the NDAA detention provision itself, has no statutory prohibition against locking up American citizens or anyone picked up here in the United States itself. While we continue to believe it would still be unlawful for a president to try indefinite detention of an American citizen in the United States again, there is no reason for Congress to risk it. When Congress considered the NDAA indefinite detention provision in 2012, the uproar from across the political and ideological spectrum was deafening. But it narrowly passed, and President Obama signed it. And when the president signed it, he made a promise as part of his signing statement that he would not use it against American citizens. But that's it. It was a promise. He never said, and nowhere did either President Obama or President Trump deny that either they or future presidents would have the power to order military detention. The loaded gun was left on the shelf. The Corker-Kane AUMF would make the NDAA detention provision an even greater threat to civil liberties and human rights. While we share the frustration of many senators with expansive presidential claims of war authority, including Senators Corker and Kane, who have over and over again expressed their frustration with that, the proposed Corker-Kane AUMF would cause far greater problems than it would solve. The ACLU strongly urges all senators to oppose the legislation. Thank you again, Mr. Chairman, for holding this hearing and considering these views.
Thank you, Mr. Anders. And because I believe in being kind and welcoming to guests, we're going to let our guests go first today, and we'll start with Senator Sanders.
Senator Paul, thank you very much for holding this hearing, and let me thank our panelists for, without exception, their very cogent testimony. Article 1, Section 8 of the Constitution states very clearly, and I quote, "Congress shall have the power to declare war," end quote. The Founding Fathers gave the power to authorize military conflicts to Congress for one very simple reason. Congress is the branch of the government that is most accountable to the people. There is no question but that over the years, Congress has allowed its authority over this very important issue of war-making to ebb. It is time for us to reassert that authority and to start asking some very tough questions about the wars, and I use the word wars, W-A-R-S, that we are currently in. Now, some people may think that this is an interesting, abstract discussion. We have brilliant constitutional scholars, wonderful intellectual debate. But let me assure every person here that the abdication of Congress to its responsibilities over war has had incredibly dire and horrific consequences for the people of our country and, in fact, the world. So I want to bring this down to earth and away from an abstract, although enormously important constitutional discussion. I want to give you 3 examples in recent American history where Congress did not ask the right questions, abdicated its responsibility, and the consequences were enormous. Very few Americans know that when we deal with Iran, very much in the news right now, how many people know that in 1953, the United States, along with the British, overthrew the democratically elected government of Mohammad Mossadegh, reinstalling authoritarian rule under the Shah. In 1979, the Shah was overthrown in the Iranian Revolution, bringing to power an extremist anti-American government. In 1953, the United States government, without congressional approval, thought that it could simply remove the government of Iran in order to protect wealthy oil interests. And what has been the consequences of that over the years? Congress abdicated its responsibility. And the second one, more relevant to my generation, was the war in Vietnam. In 1964, now Iran took place under Eisenhower, Republican. In 1964, Lyndon Johnson, Democrat, otherwise, in my view, a very great president. But in this instance, cited an attack on a U.S. ship in the Gulf of Tonkin as a pretext for escalating the U.S. intervention in Vietnam. But we now know from his own recordings that Johnson himself doubted that story about that attack. Johnson's administration misled both Congress and the American people into a war that resulted in the loss of over 50,000 American soldiers and over 1 million Vietnamese. Congress was lied to. There was no serious debate about American intervention in that war. Third example, more recently, that we all remember was Iraq. Today, it is now broadly acknowledged that the Iraq War was a foreign policy blunder of enormous magnitude. In this case, the Bush administration lied to the American people, claiming that Saddam Hussein had weapons of mass destruction. The result of that war, the loss of thousands of brave American soldiers, the displacement of millions of people in the Middle East, and bringing us to where we are right now. In other words, what we have seen is time and time again, disasters occur when administrations, Democrat and Republican, mislead Congress and the American people, and when Congress fails to do its constitutional job in terms of asking the hard questions of whether or not we should be in a war. And I think we need to ask that very hard question today. And here is the point that I hope the American people are asking themselves. Is the war on terror a perpetual, never-ending war necessary to keep us safe? I personally believe that we have become far too comfortable with the United States engaging in military interventions all over the world. After 9/11, Congress passed an authorization for the use of military force, quote, against those responsible for the recent attacks launched against the United States, end quote. The following year, Congress passed the 2002 AUMF against Iraq. We have now been in Afghanistan for 17 years. We have been in Iraq for 15 years. We are occupying a portion of Syria, and this administration has indicated that it may broaden that mission even more. We are waging a secretive drone war in at least 5 countries. Our forces right now, as we speak, are supporting a Saudi-led war in Yemen, which has killed thousands of civilians and has created the worst humanitarian crisis on the planet today. Clearly, these outdated and expansive AUMFs have been used by 3 different administrations, Republican and Democrat, as a blank check for the president to wage war without congressional consent or oversight. Meanwhile, we are currently, quote unquote, fighting terrorism in some 76 countries with an estimated cost of $5.6 trillion and untold lives lost since 2001. I think it is very clear, and our panelists, I think, made the point extraordinarily well, without exception, that the time is long overdue, Mr. Chairman, for the United States Congress to respect the Constitution of this country and to stand up for that Constitution and to demand that it is the Congress of the United States, not a president, who determines whether our young men and women are put in harm's way. Thank you again, Mr. Chairman.
Thank you. We'll next turn to Senator Merkley.
Thank you very much, Mr. Chairman, for setting up this hearing. And under what authority do each of you feel that we are currently in Syria taking on ISIS? Judge Napolitano?
Well, I don't think we're in there by any constitutional authority because, like your colleague Senator Sanders, I don't believe that either of the AUMFs were constitutional because they didn't adequately articulate a target and they didn't put in there an endpoint. But presidents of both parties have used sort of the vague principles that they believe are emanating from the AUMFs to justify the type of incursion that you're asking about.
Mr. Turley?
Actually, I see no authority even under the AUMFs, certainly not under the Constitution. What is unfortunately a less than noble lie that we have seen come out of the AUMFs has been that there's been the specificity as to targets, which was there really for public consumption. This proposed legislation has that same technique. It gives some specific references while having provisions that list can be expanded almost at will by the president, subject to a retroactive or some post hoc action by Congress.
Mr. Enders, do you see any current constitutional authority?
No, and at the time that the government made the decision, the Obama administration made the decision to claim that the 2001 AUMF was authority to go after ISIS fighters, Senator Paul, Chairman Paul, had legislation in that was a declaration of war focused in on, for 1 year, on ISIS. And that was a constitutional way to take on that fight.
I'm going to go ahead.
What they did instead was that they had this very tortured interpretation of the 2001 AUMF and applied it to a group that was actually at war with core al-Qaeda.
Thank you. The reason I asked you the question is 3 esteemed experts have just clarified that we don't have a constitutional authority, and yet our forces are in this battle in Syria. And I wanted to use that as a way to dramatize what's happened since 2001, in which was a very precise AUMF, very carefully constricted to those who attacked us on 9/11 and those who harbored those 9/11. And since then, it has been stretched and expanded to country after country, organization after organization. I think you all agree with that characterization of 2001 being stretched beyond recognition, such that it does not really provide a constitutional foundation for current conduct of military forces in these countries. So now we're at this point, this point at which people are saying 2001 shouldn't be allowed to continue. It's been abused so much, and we have the Corker proposed AUMF. I have an impression that when you analyze the details of it and what it authorizes in multiple organizations and multiple countries, with the president allowed to add an additional list, and that additional list can be added without pre-authorization by Congress, that it essentially codifies the expansion, the stretching of the 2001 AUMF. Is that a fair way to describe it?
Yes, it's a loaded gun.
Yes. Okay, yes?
At minimum, yeah.
Yes. So Senator Corker, who I deeply respect for having wrestled with the 2001, and Senator Kane have tried to figure out how to replace 2001. They've come up with this proposal, which disturbs me for the reasons that you all have been sharing. But Senator Corker fairly said, so if you all don't like this, what would you do? And Mr. Anders, you mentioned, I think your closing comment was you encourage members to consider presenting what could all be done as an alternative. So I've presented such an alternative. I don't know if each of you is familiar with it, but one of the things it does is have a sunset in it, so it periodically would require us, as the Senate and House, to re-examine the foundation and the considerations. Do each of you think a sunset is an important provision in AUMF so we don't have unending war without reconsideration or reauthorization by Congress?
Well, a sunset, Senator Merkley, is certainly helpful because it compels the Congress, the representatives of the people, periodically to review what the president is doing in their name. My own view would be legislation which simply says the president shall not use military force, military or civilian, because presidents use intelligence forces and thereby bypass the war powers resolution.
So my time's going to run out, so I apologize.
All right, I didn't mean to take, except in accordance with the Constitution.
And so, Mr. Anders, I know you have seen what I've put together to try to very tightly constrain just to 2 countries and 3 forces and put a 3-year sunset on it and require any expansion of that by the president, including an expansion to ground forces, to require pre-authorization so we have the constitutional vision represented at AUMF. Any insights on whether that puts us more clearly on the track envisioned in our Constitution?
Yeah, we are really pleased with how you put together your AUMF. We don't take a position, the ACLU has never taken a position on whether the United States should be at war against a particular country or particular group. But in terms of how it fits with the Constitution separation of powers, the AUMF you put together fits very well. I mean, it's up to Congress then to make that decision on, do we want to be, as a country, be at war with these particular groups and these particular countries? But in terms of kind of fitting into a constitutional framework, yes, it does.
I just want to note that several of you pointed out that members of Congress are uncomfortable with having to make these tough decisions. And so it's easy to take what was vested in Congress and simply deliver it to the executive and let them take the heat. I find that unacceptable. I find this inversion of the Constitution, this proposed inversion, in which the president can go at forces in new countries, new organizations, deciding on his or her own whether or not it meets the test that's in the AUMF, and that Congress would have to come around after our forces are deployed and get a supermajority of both chambers to close the door. Something that nobody thinks Congress would ever do. So in sum, we end up with a wholesale transfer of our responsibilities, carefully crafted. It's tough for us to make these decisions, but it's our responsibility, and it's why we need to craft a replacement AUMF that honors that vision of the Constitution and makes us have the tough debates and the tough votes. Thank you.
Senator Udall.
Thank you, Mr. Chairman, and really appreciate your calling this hearing and having these 3 experts before us here. Mr. Anders, I asked the following question to Secretary Pompeo over at the Foreign Relations Committee and wanted to get your perspective on this. The Chief of Staff of the Army, General Milley, reminded us recently in an appropriations hearing of the nature and character of war. The traditional idea is that war at its base is an extension of politics. War forces our will on the opponent through military means to reach a political objective. Taking an expansive view of what Congress approved on 9/11, the political objective is to stop terrorism at a broad level. However, a more restrictive view, and the view that was sold to the Congress when I voted in favor of that 9/11 AUMF, was that we aim to punish and deter the perpetrators of the 9/11 attacks, specifically al-Qaeda and the Taliban. Which view do you believe is the correct one, Mr. Anders?
That's easy. I think it's the narrower view, and I think Congress at that time worked hard to come up with specific language, and there was a back and forth that has been reported on quite a bit. It was reported on at the time between the White House and drafters in Congress on coming up with that language. And the part that is frustrating, I think, for all of us now is when we talk about new AUMF, we're talking about the need for specificity in naming your objectives and naming the enemy. It's hard to see how that 2001 AUMF could have been made more specific than it was in terms of naming what the objective was and who it was that the United States was going to war against than what it was. The only shortcoming in it was that given that the United States at that time didn't know the exact names of who it was we were at war with, it didn't include the exact names. But other than that, I think it's pretty clear that it was for core al-Qaeda because of their role in the 9/11 attacks and the Taliban for harboring them. Period.
Yeah, one of the restraints on war was recently put in a commentary by Dr. Sarah Krebs over at Cornell, and she's the author of a new book called Taxing Wars: The American Way of War Finance and the Decline of Democracy. And she really makes the point that when you have a tax on war, you're involving everyone. Everyone understands that the society as a whole is backing this war. And so in the distant past, we paid for wars with war taxes. More recently, members of Congress have proposed these taxes to raise public awareness about the costs of war and to share the sacrifice beyond a small percentage of Americans who fight in these wars. What do you think of a proposal for a war tax? Rather than, and I know, digging us deeper into debt.
I do think the bigger point of having the country have a greater investment and a greater knowledge of what the costs of war are. One of the problems that we've had with the lower cost of war in terms of American lives and American treasures with the use of drones and new technology is that a lot of the more obvious costs of war are not as apparent. So, focusing in on what the financial costs are would probably be a very helpful way for people to have a better understanding of the full extent of what this actually means.
Yeah, and I think you'd end up having a debate about whether or not to commit ourselves to many of these very dangerous situations. Along that same line, some people, and when I go home and do town hall meetings and hear from my constituents, some have asked, why are we not seeing people in the streets like in Vietnam or anti-war activity on our campuses? And the answer I always get is there's no draft. Should we relook at this? Do you consider a draft a check on foreign wars?
In the past, and certainly I've been at the ACLU 20 years, it predates my time there, but I know we've had a lot of concerns historically about a draft in terms of its impact on civil liberties and also in terms of equality and who is subject to it. So that's not a proposal that we're supporting.
Yeah. The Office of Legal Counsel recently released its legal justification for the strikes in Syria. The memo states that the President identified 3 interests in support of the April 2018 Syria strikes. 1 was the promotion of regional stability, 2, the prevention of a worsening of the region's humanitarian catastrophe, and 3, the deterrence of the use and proliferation of chemical weapons. The OLC relies on the President's Article II authority. And as Harvard professor Jack Goldsmith says, the Justice Department now officially and publicly believes the President can use significant air power without congressional authorization on the grounds of humanitarian intervention and deterrence of the use of chemical weapons. I find that OLC opinion extremely alarming. Do you agree with the Justice Department that these strikes can be justified via Article II authority alone?
As disturbing as some of the claims made based on the 2001 AUMF have been, that opinion, the May 31st, 2018 opinion on the Syria strikes, strikes on Syrian targets, and the April 1st, 2011 opinion during the Obama administration from the Office of Legal Counsel on the air campaign against Libya are chilling. They both are essentially the President claiming for himself the war authority that the Constitution gave to Congress alone. And they are very expansive claims. And I think a lot of us thought that the Libya opinion was about as aggressive and as expansive as one could be, and that was only topped last week with the one on Syria. And I do think that's a challenge for the Senate to figure out how to use the legislative process to pare that back, to invalidate those opinions and those relying on them. But ultimately, that's probably going to require also using the power of the purse and cutting off funds for unauthorized military campaigns.
Chairman Paul, thank you so much for this hearing.
Thank you. Senator Lee.
I want to thank Senator Paul for organizing this hearing, and I want to thank the three of you in particular for your willingness to come and offer your expertise and the insights that you've offered today, which are really helpful. We're now in our 17th year of deployment under the 2001 authorization for the use of military force. It is not yet the case that our most junior personnel deployed were not born as of the moment that 2001 AUMF was issued by Congress, but it will soon be the case. Long before it's even fathomable that we will have retreated from these battlefields, it will be the case that this AUMF was issued before they were born. In the meantime, we've got some issues to deal with. You know, we've spent $2.8 trillion in these efforts under the 01 and 02 AUMFs. And there's not a lot of accountability that comes when Congress continues to look the other way or tolerate ongoing efforts, ongoing deployments consistent with those 01 or 02 AUMFs without having additional discussions on what exactly we're doing, on why U.S. blood and treasure should be put on the line. And so instead of the people's elected representatives debating, discussing these things in real time, these issues have been left to the will and the whim of a small handful of political elites in Washington, D.C. This is scary, and it's contrary to the text and the structure and the history and the tradition underlying our Constitution. So it's one of the reasons why I welcome this hearing and why I think we need to have this discussion. So I've got a few questions. We'll start with you, Mr. Anders. Earlier this year, as you're probably aware, members of Congress received a letter from the Department of Defense relying on a 1975 argument suggesting that the only time Congress has a role, an indispensable role in authorizing U.S. forces to be deployed is when deployed units of U.S. forces are on the ground engaged in a kinetic exchange. Do you agree with that, and if not, why?
No, we don't agree with that. And that's, first of all, it's the role of Congress to provide, and it's their exclusive authority to provide authorization in advance before a military engagement in the absence of a need to repel a sudden attack. And that's the constitutional standard.
And it's often not how we fight wars today anyway. I mean, there are there's lots of kinds of warfare that we engage in today that doesn't necessarily involve a kinetic exchange between people on the ground.
That's right, and I think this again is something that began during the Obama administration. This definition of what hostilities mean under the War Powers Resolution, and what the position that the President Obama eventually took was that hostilities did not include air power in the absence of ground troops. And that, of course, means that lots of places, as you just referenced, where the United States is at war, are not considered hostilities. And so, therefore, the War Powers Resolution, which does include deadlines for withdrawing in the absence of congressional authorization, don't apply. So with that opinion from Harold Koh, then the legal advisor at the State Department to President Obama, the executive branch pretty much wrote out of existence a good part of the War Powers Resolution.
Which is of concern to many of us here and ought to be more so than it is within Congress. Professor Turley, as you know, it was well understood at the time of the founding and was made an understanding based on how the Constitution was written that the president, unlike the king, would not have unilateral power to go to war. In fact, Hamilton makes this point in Federalist number 69. So when people talk about the immense power vested in the executive to deploy military personnel, from what source are they claiming that authority exists?
There is no source. The interesting thing about this particular provision in Article 1, Section 8 is it was viewed at the time as the defining work of the convention. That is, you had framers who joined together who were normally not in agreement and said, this is how we can address this. They all agreed that they didn't want a situation like the one we have today, where a president has this type of unilateral authority, and they believed they had fixed the problem because Article 1, Section 8 could not be more clear. And to fold this back to the question that you asked my colleague, the definition that the President put forward of this kinetic conflict was used in the litigation that I led on behalf of Democratic and Republican members. So the Obama administration came forward when we were challenging the Libyan war as an undeclared war and came into court and said, you know what, it's not a war by our definition. And when we had that argument, they went further than that. And they said, the President alone defines what war is. Now, we presented that to the court and says, does that track with you? Do you honestly think that the framers put this specific of an obligation, spent this amount of time, and it all comes down to a noun that the President is simply allowed to define? By the end of the litigation, by the way, I had no better idea of what kinetic means in wartime than I did before, but what I did understand—
It means you're hitting stuff, I think.
Yeah, I guess so. But it got to that point of absurdity. And this is all an effort to avoid clarity. You know, you try to change the noun if you can't deal with the obligation.
To avoid clarity, I think that's a good description. To avoid clarity in a place where morality, decency, and justice would seem to demand clarity, and where the Constitution provides clarity. Judge Napolitano, I want to talk to you for a moment about the Associated Forces doctrine. Executives from both political parties for decades now have used this as justification for a number of military operations. But when I read the text of the 2001 authorization for the use of military force, it seems somewhat clear to me that it covers a fairly narrow scope of targets to include, quote, those nations, organizations, or persons that he being the President, determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons, close quote. Can you explain to me the limits of this AUMF, meaning what groups or geographic regions the U.S. could legitimately go into under this authority?
Well, Senator Lee, I have argued that the AUMFs, both of them, 2001 and 2002, are unconstitutional because they failed to include an endpoint. And that's the reason we're having this hearing today, because presidents have used these to go wherever they wanted to go. I mean, George Orwell predicted all of this when he said words would determine liberty. If the president can define war rather than the Congress defining war, he or she will define it in a way to facilitate his or her use of it. I mean, at one point, the Obama administration argued that the use of intelligence forces on the ground who weren't wearing uniforms with insignias on them is not the same as military forces on the ground. Well, they looked a little different because they didn't shave every day, but they were carrying the same type of offensive weaponry with which to kill people that hadn't been authorized by the Congress. So the use of the phrase associated forces and permitting the commander-in-chief to define what those mean, I used this phrase earlier with Senator Merkley, is like Justice Jackson said, dissenting in Korematsu, a loaded gun in a desk drawer of the president, ready for him to take it out and shoot it whenever he wants.
Well said. I see my time's expired. Thank you, Mr. Chairman.
Senator Peters.
Thank you, Mr. Chairman. And gentlemen, thank you for your testimony here today, and certainly a interesting discussion. But I wanted to take my time and discuss something that's actually happening right today and get your sense of what you're seeing and your thoughts. Today, the Senate, as you know, is starting debate on the National Defense Authorization Act for 2019. And the bill that was before us includes a provision that will allow the Secretary of Energy to pursue development of a low-yield nuclear weapon without first receiving specific authorization from Congress. I voted against this provision as a member of the Armed Services Committee, and it literally strikes from current law a requirement that a new low-yield nuclear weapon be, quote, specifically authorized by Congress, and it replaces it with a provision that will allow the Secretary of the Energy to decide on his own. whether or not to go forward. The provision that is struck was a limitation that Congress put in place about 15 years ago to ensure that the legislature and not the executive branch would make such a highly consequential decision. I would argue if members of Congress think that our arsenal needs a low-yield nuclear weapon, that we should debate it. We should authorize it and do it in full view of the American people as existing law requires. Instead, some are trying to change the rules to allow the executive branch to make this decision without congressional approval. I think that's fairly clear. So for the panel, just what are your thoughts, and is this an appropriate delegation of congressional responsibility?
In my view, Senator Peters, it is not. I would have commended you and do commend you for your vote and for your understanding. The point I tried to make in my initial comments was it is often the subtle and unseen passage of power from the Congress to the President that comes back to wreak the most havoc. Quite frankly, as a person who monitors this, I was unaware until you discussed this just 2 minutes ago that this is being debated by the Senate today. This is profoundly hideous and utterly unconstitutional, that bureaucrats in the executive branch would have power that Madison and company expressly gave only to the Congress.
Any others?
Oh, I would simply add that I do find it very problematic in terms of using the appropriations process as a substitute for an authorization and a full debate. You have two former House pages here. We won't tell you the years we served, but you can look it up because what I'm about to mention, when I was a House leadership page, we had the debate over the neutron bomb, of whether to allow the neutron bomb to be developed or whether it was a new type of weapon that would make nuclear war more feasible and therefore more likely. I stood there on the House floor listening to that long debate that went into the earliest hours. It was one of the most profound experiences of my life, and I came away with a deep respect for members on both sides that spoke honestly, directly about the consequences and the issues behind that type of weapon. And I remember thinking as a young page that this is a pretty great place when we debate whether we should do something, not whether we could do something, and what implications does it have, not just for us, but for the world. That's a debate that I think you should always want. The other point I was going to mention is in my testimony, I talk about the problems that we're having, not just with the failure of Congress to carry out its duties under Article 1, Section 8, but its collateral failure to deal with its obligations under the appropriations powers. When we fought against when we litigated against the Libyan war, one thing a lot of people didn't realize is that war was completely paid out of loose change. Congress never appropriated money for the Libyan war. We had an entire war that was paid for because Congress gives so much money to the Defense Department, they can actually have a war based on the money you give them and don't commit to. So the failure is on both sides of this issue.
All right, I appreciate that. And, Mr. Andrews, I'm going to ask you to answer a little different question, but picking up from this debate on nuclear weapons and the consequential nature of them and why congressional input and debate is, in my mind, essential, and it seems as if both of our previous witnesses would agree with that. I spent a great deal of time thinking about the future of warfare, which was going to change in absolutely dramatic ways. I'm intimately involved in self-driving cars and autonomy and things that are happening in that scope, and it's driven by artificial intelligence, machine learning. We are going to have the face of warfare will be radically changed in the next 5 to 10 years. I think it raises some profound issues, certainly of the morality and ethics of what we're dealing with, but also some significant policy issues, and perhaps a view of what Congress's involvement should be, given the fact that this technology is changing rapidly and our adversaries may not be bound by the same types of constraints that we have here. So just want to get your thoughts. What should we be thinking about in terms of war powers, given the fact that technology will be changing dramatically and in profound ways? And I know you mentioned a little bit about that earlier, Mr. Andrews. I'd like to hear your thoughts.
Yeah, I think this is one place where the need for specificity, the need for controls, the need for limitations put in at the get-go is really important. And I think you know we're there are places where or there are instances where there are members of the Foreign Relations Committee that have come up with, various amendments to various AUMFs that have been in front of them, limiting some of the limiting operationally what can be done in different theaters of war. But I think, kind of even more fundamentally, limiting the geography, limiting who the enemy is, are particularly important. And I think, kind of going a little bit to, back to the question about, the provision today, I think if Congress hasn't learned anything over the past couple decades, other than that when it's a one-way ratchet wrench with turning any kind of authority over to the executive branch. So that if you provide discretion to the executive branch, you are not getting it back. And so the starting point for an authorization for use of military force or a declaration of war or any kind of new weaponry ought to be controls imposed by Congress. And if later on those controls need to be loosened, then loosen them. But the greater and the tighter control you put on from the start, the more likely it is that Congress is going to retain that authority.
I'm out of time, Mr. Chairman, but if anybody had a quick thought on that, I would entertain that.
Fully agreed.
Good. Thank you.
Thank you, Senator Peters. It was mentioned earlier that our soldiers within the next year will actually have been born after 9/11 and have no memory of it. We've been at war that long. Even many of the audience here today is young enough that they may not remember 9/11. And it's not to say it wasn't something profound and that we needed to respond, but we're still at war, and I think we've lost our mission. I asked Secretary Pompeo when he was before us, is there a military solution to Afghanistan? And he frankly said no, and he's one who still wants to stay. And my question, if there is no military solution, why would we add more troops? I'm reading Stephen Cole's book now, Directorate S, about Afghanistan and Pakistan. And in that book, in 2010, the Obama administration admitted there was no military solution. In the book, there's a discussion, and it says unanimously everyone agreed there was no military solution in 2010. So we have to wake up and do something. That's part of what this hearing is about. But it's also about the constitutionality of authorization to use force, a declaration of war. And so I think that it's important that we review these again. I think there are possibly two reasons why this is unconstitutional, and we'll start there. One, I think it delegates authority, that's congressional authority given by the Constitution to Congress, to the President. Why don't we start with Judge Napolitano and Professor Turley and say, how is that unconstitutional? Is there a possibility that we can go to court? Is there evidence that we've ever had a delegation doctrine overturned where Congress delegated some of their authority they weren't allowed to do? Judge Napolitano first.
Well, Professor Turley is the country's expert on getting cases into court that seem impossible because it looks like there's no standing, but he manages to find it. So I'll let him address that. But the Supreme Court has held countless times that just because the branch of government that is losing the power consents to that loss does not make it constitutional, because the separation of powers doctrine was not written to preserve the prerogatives or the hegemony of the three branches, but rather to preserve human liberty by keeping the branches at tension. Madison even said jealous of each other. The problem, of course, is getting the courts to examine this. There have been some examinations, but they are few and far between. Professor Turley is an expert in that because most of the time the court will say, particularly with respect to war, we're not talking about Congress saying to the FDA, you can make all the regulations you want about toothpaste. We're talking about with respect to war, the courts are more likely than not to say that is a political question. If you don't like the war, elect a new president or elect a Congress that's more faithful to its oath to uphold the Constitution. But just because that power passes from legislative to executive with the consent of both does not make it constitutional. In fact, the core authorities of each branch may not be exchanged, mixed, or commingled with either of the other branches. If the court is clear on anything, it's clear on that.
Professor Turley?
Well, thank you very much. there is this strange anomaly, which is largely a creation of the judiciary, that exists today. Most people, when they learn civics, believe that if something is unconstitutional, then the courts have a chance to review it. And so the sense is that the checks and balances work in the tripartite system because no one can act alone. Unfortunately, that's not true, because the courts have developed narrowing standing doctrines that I've long been a critic of. You actually can have glaring unconstitutional acts where the court will not recognize anyone as having a right to raise them. So, for example, in the Libyan war case, I came forward with both Democratic and Republican members who said, look, we take an oath, and that oath includes uphold the Constitution, which includes an obligation, a sacred one, to declare war. We were denied that right, and so we have standing.
Is the standing issue a problem at every level, district court, appellate court, and at the Supreme Court?
It is, and the court on that occasion said no. And when I pressed the court saying, then we have here an immaculate violation of the Constitution. Literally no one can stop an undeclared war, even though the framers considered this one of the great violations they sought to avoid. Now, when I went back to the court, when I represented the House of Representatives as a body, there was a fierce level of litigation, but we won that standing battle. And the court accepted that as a representative of one of the houses, my clients would have standing. I really believe that...
And then did it go beyond the district court, or...
It went to the Court of Appeals, and eventually it ultimately proved moot because of the changes we saw.
So you didn't lose on standing, lost on another
No, we
issue.
won on standing, and that thankfully is still there. But I believe legislative standing would solve a lot of this problem if members of Congress were recognized as having skin in the game.
But it sounds like it's overwhelming within the federal court structure that both precedent and opinion is that, it won't change unless all of a sudden there were a majority of the Supreme Court to sort of set a new way on standing.
That's not impossible. I mean, the fact is this is a creation of the courts, and it can be undone by the courts, but it's not working.
In Hampton versus the U.S., they set forth, like a lot of things the Supreme Court does, says you're not supposed to do something. Well, you can do it if it's intelligible or reasonable. We get all these extra doctrines added in, which I think basically dilute what you weren't supposed to do once upon a time, according to the Constitution. But in that, they said you can't delegate your war-making authority, but you can give up some of it if you have an intelligible principle upon which to act. Has there been further decisions in that vein? Is that sort of a last standing precedent as far as this goes with war powers? Are there other court cases that we can look to that are instructive in this? We'll start with Professor Hurley and then Judge Napolitano.
Well, actually, I think there is some reason to be hopeful, particularly in the war powers area, but also more generally in terms of separation of powers. I had the honor of testifying in the Gorsuch confirmation hearing, and one of the things I said about Justice Gorsuch as a nominee is that he had a certain refreshing understanding of the separation of powers, and some people view him as a textualist in that sense. But we really can change the center of gravity here and move it back towards the legislative branch. Because right now we have a dangerous instability, and so far, Madison, you'll never hear me say this in a given day, but I'll say it here. Madison may have been wrong. He was proven wrong by members of this institution when he said that ambition would fight ambition. He believed that you all would be just jealous over your inherent authority. You wouldn't let anyone take it away. But this institution has really shattered that assumption.
Certainly there's ambition, it's just misplaced.
Maybe Madison meant courage, because the Congress has really lacked the courage. Those of you who are here today have the courage to say to the executive, you have to stop. I mean, the most frequently cited, at least until recently, justice in American history, Benjamin Cardozo once said, where there's a wrong, there's a remedy, except when the president wages war and there is nobody who can get into court to challenge him. So Professor Turley is living proof of that, though he's had some unique successes. Congress has to write the legislation, whether it's on standing or whether it's no president shall engage in any act of violence, whether by people in uniform or not, except in accordance with Article 1.
And it's easy for us to deflect and say, oh, well, the court should allow standing and the court should fix this, when in reality we probably need to look in the mirror and aggressively use our ambition to take our power back. On the question of constitutionality, so we've talked about the delegation. We're giving up authority that was constitutionally given to us. I think there's a slightly separate issue that goes to constitutionality as well, and that is changing something that is can only happen by a positive affirmative vote of a majority to something that can only be stopped by a 2/3 vote of disapproval. And the way I think is important to look at this is like on spending bills. Congress is supposed to spend bills. The president can't spend any money unless a majority of us give him the money to spend. That's the way it goes. It has to be a majority. It would be like us saying to the president, you can spend all of the money, and the only way we can stop you from spending the money would be by a 2/3 vote. Who in the world would think that that was possibly constitutional? But I guess my question is this: is that separate? Would that be a separate constitutional issue from the idea of delegation of authority? Because what we're actually doing is switching something. We're switching. The Constitution has certain things that are done by majority vote affirmatively, and then has actually almost everything's affirmative, but then there are some things that are supermajority. So are we not just changing the Constitution? It's unconstitutional because of it's a change. It's not necessarily a delegation, but actually a change in the mechanism of the way the Constitution works. Professor Turley?
It is certainly a change. The Constitution is quite clear. You need the authority of Congress to go to war. This proposal gives you a post hoc measure, which we all understand will never occur. It's going to be very hard to get a veto-proof majority to take the name of an accused terrorist group or nation off that list. And so it's going to be virtually impossible to do that. But it doesn't even matter how you feel about the logistics or the likelihood. It is in direct contradiction of the Constitution, and it's a bizarre notion. As you said, if my two boys here came to me and said, look, instead of Mike asking for the credit card, just give me your credit card and you can stop me when you see expenses get too high.
Isn't that what happens?
I think we would look at them and go, well, that wouldn't be a really smart idea. What's weird about all this is that the framers were right. That is, everything we're talking about right now proves that they were right. They were right about war. They were right about appropriations. They really did know about human nature in that sense.
Look, the imposition of the supermajority is profoundly unconstitutional. The question is getting a court to declare it as such, which is nearly impossible.
Or us grabbing it back. I have another question, but I've gone on over time, and I wanted to see if Senator Peters had any last. You good? The last question I wanted to bring up was something that Mr. Anders brought up, and I think is an important point I hadn't thought of until I read his statement, is that, one, it's a real problem that associated forces are sort of out there, and the president will define what they are in the future, and then we can only stop him with a 2/3 vote. But it's also an interesting question that you bring up, that associated forces are not defined to be foreign enemies necessarily. Right. It could be a domestic group that you don't like that could now be associated forces. And you could see how, this could be, a variety of. I mean, you really can imagine groups. We won't go into all the imaginings of which groups, but there could be domestic groups you could say are associated forces. And your point is that the indefinite detention of citizens that has been legalized through the previous defense authorizations could then be applied to vast groups of American. Can you make that a little more clear for us and re-explain exactly what you mean by that?
Yeah, so this is a problem with the Corker-Kane AUMF. It was a problem with the NDAA. It was a problem with the NDAA detention provisions. It was a problem that the Senate, by vote, refused to fix, despite the votes of people sitting on the dais who voted to protect American citizens there. But there is no prohibition in the Corker-Kane AUMF from designating an American group, American citizens, an American individual from being an associated force that the president could decide on his or her own is an enemy of the United States. Similarly, there's no prohibition in the Corker-Kane AUMF from designating the United States as a place where military force can be used. Now, we take it for granted because of posse comitatus, which is probably more limited than the kind of legend around it makes it seem. That
posse comitatus limits federal officers from, or the Army from operating domestically.
That's right, for law enforcement purposes.
But I guess
and-
one of the questions would be, who's the Army and who's intelligence officers or Homeland Security police? Are they the Army? Are they limited by posse comitatus?
That's right. That's right. But in this instance, there's nothing in the Corker-Kane AUMF that says that the United States cannot basically become a battlefield. And this is something that came up during the debate around the detention provisions in 2011, with Senator Graham going to the Senate floor, saying that the United States can be a battlefield. So this is a real problem, and there have been United States citizens that have been droned accidentally, droned on purpose, as you know, Mr. Chairman. There have been United States citizens that have been put in indefinite military detention. So these are not theoretical problems. Now this is one aspect, of course, of far bigger problems with the Corker-Kane AUMF. But this is one that I think, especially as we noticed that it was kind of tucked in there with this innocuous name, just saying, that these provisions of the NDAA are getting amended by adding the name of the new AUMF into it. It's a broad new authority that would be handed over to the military.
I know Judge Napolitano has a plane. If you want to escape, we're going to let you escape, but I know Senator Sanders had a few more minutes of questions. I'm going to leave that up to you whether you can stay or go.
Very briefly, I apologize, but I had a pre-scheduled meeting that I had to be in. And thank you very much for your excellent testimony. Let me ask you this question, and you may well have gone over it when I wasn't in the room. When we talk about giving the president today virtually complete authority, if we read in the paper that the president decided to bomb someplace tomorrow, nobody would blink an eye, right? That's what we've seen for decades. You talk about the precedential impact of allowing presidents to do this. What does that mean above and beyond wars, above and beyond abrogating the Constitution of the United States? What does it mean to our quality of life in this country?
Oh, I think it's the fact that we're having this kind of a conversation about whether the president could kill Americans in America or whether the president can engage in perpetual war, no matter how noble he believes that cause is, speaks volumes about how low we have sunk with respect to culture, morality, and fidelity to first principles in the Constitution, Senator Sanders.
Okay.
I think that there's really a twofold problem here. One is that, Benjamin Franklin, as you, I'm sure, recall, at the convention was asked by Mrs. Powell, what was it that you have wrought? What have you created?
Is that really true, by the way? Did he really say that?
That's a fact that I don't want to check.
News? I don't know.
Only Jonathan believes that actually happened.
Right, and he said, it's a republic if you can keep it. And that is the problem with being in perpetual war, is that my boys have never lived in a country that has not been at war. Both of them have literally never spent a day of their lives when we have not been at war. It becomes a natural state. And the example of that is one of the most chilling things I saw in my lifetime was when Eric Holder went to my alma mater law school to announce the kill policy of the Obama administration, said that the administration was now asserting the right to kill an American citizen on the president's sole authority without charge, without conviction, and that he believed he had that authority that was inherent in Article 2. And instead of having any objections, a room full of leading law professors and judges applauded an attorney general saying the president has the inherent right to kill any of you. And the reason this becomes dangerous is take a look at the OLC opinions that we talked about recently. In the OLC opinion, they argued the president had unilateral authority to go to war without the approval of Congress because of, quote, the historical gloss of past wars. So what has happened is that this body, because it has acquiesced for so long, that is now being used as an interpretive
That's the precedent that they're using.
That's right.
Yes.
Yeah.
Senator Sanders, I was really struck by something you said earlier, which was to talk about kind of what this is like, what this is all about in reality,
Right.
as opposed to theory. And I do think that one of the dynamics around this discussion about putting together a new AUMF is that this has become kind of a lawyer's game among lawyers about law, right? It's like one big logic game. And you know, it's telling here, although, you know, I don't want to be off this panel, right? But we're all, you know, 3 lawyers here on this panel. Literally one hearing in front of the Senate Foreign Relations Committee was 2 lawyers there. The earlier versions of this, which, you know, kind of came out of some of the Lawfare blog writers and thinkers there, there were panels both in the House and the Senate earlier. There were all lawyers on those, right? And a lot of it just gets tossed around as well, kind of how we haven't done this in 17 years, so how do we like rearrange the words on the page? Right? And you know what? One of the things that, you know, we've been trying to bring home to people and talking about the Corker-Kane AUMF is, you know, without even going to new groups, you know, look at it has Al-Shabaab and it has Somalia, right? I have a 16-year-old too, all right? Do I want my 16-year-old going to war against Al-Shabaab in Somalia? My son probably can't find Somalia on a map, and probably very few people even in this room know who Al-Shabaab is, right? But this basically would be Congress. Now, that's not even like turning what the president comes up with.
Right.
This would be Congress saying the United States can go to war against Al-Shabaab in Somalia. That doesn't mean just sending a drone there, here and there, right? That means if the president wants to send 200,000 troops there and go in all-out house-to-house fighting,
Right.
as we did in Afghanistan and Iraq, we could do that. And
All right,
Congress would
my
be on
time
the
is
hook for it.
expired. Let me just, Senator Paul, thank you very much for calling this here. I thought I'd missed some of it, but what I heard was just really very important, and I want to thank all 3 of you for your efforts. Thanks for being here, and thanks for all you're doing.
To put a human face on this, you might ask the families of the 4 soldiers who died in Mali chasing a herdsman, should we have discussed whether we needed to chase that herdsman, what that herdsman's threat to our national security was, what kind of war is going on in Mali? We've had no hearings on a war in Mali. In fact, a prominent member of the Armed Services Committee in the Senate said, Mali, I didn't know we had 1,000 soldiers there. Mm-hmm. So, I mean, that's very worrisome that the people who are supposed to be informed, that are supposed to be debating whether our sons and daughters die in foreign wars, aren't even debating it at all. We've completely abdicated it. And there is a bipartisan group of us who would like to grab that back, but I can tell you we're in the minority. And we'll finish with this last question. The majority of the Senate, and I think Senator Sanders would agree with me, actually do believe in unlimited Article II authority on both sides of the aisle, maybe more so on my aisle, but even some on the other side of the aisle do believe that there is unlimited Article II authority. In fact, they say that, I've heard this said many times, that the only check we have is the power of the purse. And I said, well, that's one check, but that's not the initial. We have a check on the initiation of war and then on the continuation through spending. But it's virtually impossible to stop funding when a war is over there because people say, well, you're not going to fund, you know, our young men and women. You're not going to give them the arms to defend themselves. How can you do this? And even in Vietnam, which was so incredibly unpopular, funding didn't. I think there was finally a vote in committee. I think Senator Leahy was there, and he tells a story about being there and voting. But it was like 74, I think, or 75 almost, by the time we had the courage in one committee to vote to stop funding. So I guess my question, though, is there any historical evidence that our founders believed in unlimited Article II authority, or that the declaration of war was is just now an anachronism that our founding fathers did not find to be important? We'll start with Judge Napolitano and work our way down.
Well, that's a short answer. There is no evidence that the founding fathers believed in unlimited Article II authority, and there is an abundance of evidence, which Professor Turley characterized in his opening statement, that they did not.
Yeah, there are plenty of systems that give that type of authority. It just doesn't happen to be ours. The framers were quite clear to the contrary. They couldn't. This is one of the few areas where there wasn't much of a debate. In one case, there was a single person who was suggesting this view that a president should have this authority, and he didn't get a second on his motion. And so, my preference is that if you want to gut Article 1, Section 8. Do it. Don't blame the framers, and don't pretend that it's in compliance with the Constitution.
Madison's gotten a lot of attention today, so just to put out Thomas Jefferson and give him a little airtime.
This is where I cut off your mic.
He wrote, an allocation of war powers to Congress provides an effectual check to the dog of war by transferring the power of letting him loose from the executive to the legislative body.
Well, I think this has been a great hearing. Thanks, everybody, for coming. And if we're still at war 17 years from now, if Kane Corker passes and there are no limits on war, let it be known that there were at least some of us who warned. Thank you.
Thank you.
Thank you, Senator.